If you have not updated your estate plan in the last month, it is probably out of date. Hello, my name is Tim McCurdy, and I am an estate planning lawyer in St. Louis, Missouri. And today we're going to be talking about the Secure Act. The Secure Act is one of the most significant changes that has been made to the rules governing retirement accounts in the past decade. The Secure Act was designed to change the rules regarding IRAs, 401ks, both to encourage people and continue to encourage people to save for their retirement, but also to make significant changes to how retirement accounts can be passed on to your family and how they will be inherited. This is our second video on the Secure Act. An earlier Secure Act gave an overview of everything that the Secure Act does. I encourage you to look for that video. But just briefly, the Secure Act removes the contribution age limit for a traditional IRA. Before, you could make contributions up until 70 and a half. The idea when it was created in the 70s was that by 70 and a half you'd be retired. Recognizing that often that's not the case anymore, you may still be working. You now have until age 70, or it removes that contribution age limit, and it also changes the age when you have to start taking what we call required minimum distributions. And that's something we'll talk about in a moment, where it used to again be 70 and a half, now that's been raised to 72. And most significantly for the purposes of our video is that it removes what we call the stretch, which would be a planning strategy that existed before the Secure Act to pass on as an inheritance the IRAs to your loved ones and give them the maximum tax savings through an amount of planning. So to understand what the stretch is and why these changes are so significant, you need to think a little bit about what IRAs are and 401ks and what are they intended to be. The reason that we have IRAs, 401ks, is that the government is trying to encourage people to save for their retirement. And the way that they're encouraging people to do that is giving tax benefits to them so that throughout their lifetime they'll be putting money away into tax protected accounts so that they'll have money for their retirement as they age. But as a retirement account, they're designed to pay out during your lifetime. The goal of, for example, an IRA is that you will be able to put that money in with tax savings, tax deferral, but then once you get retirement age, you're going to draw that out to live off of it. It's not necessarily intended to be an estate planning tool to say that you're never going to have to pay tax on those funds. And the way it would work in a traditional IRA is through required minimum distributions. And the idea is that you're able to put money into the IRA. It's not tax-free, but it's tax-deferred. So before taxes come out of your paycheck, for example, you can put that money into your IRA, your 401k, and no tax has been paid on that. And you're able to keep the money in that account through to the age before it was 70 and a half, now it's 72, when the government says, okay, that's the age where you're at retirement, approaching retirement, you need to start taking that money out, and that's when the government is going to tax the money. So it's not tax-free, it's tax-deferred. The money's allowed to grow over time, so there's that benefit to growing without having to pay the tax. You can grow faster because there's more money to grow, but then the government is going to collect that revenue when you take the money out. And to keep you from just saying, well, I'm just not going to take the money out, I'm going to leave it in there, with a traditional IRA, you have what are called required minimum distributions. And they've raised the age limit. It's now at 72, but once you turn 72, you have to start taking that money out. So they would take your life expectancy. So if you're 72, you may have a life expectancy of 10, 12 more years. And for each year, they're going to take your life expectancy and your account balance, divide the account balance by your life expectancy, and that is your required minimum distribution. You can take everything out if you want, but you have to take out that required minimum distribution each year. The idea being that if you lived exactly to your life expectancy, by the time you passed away, you would have taken out all of the money from the retirement account, and the government would have collected taxes on all of that money. So I understand that this is traditional IRAs. It doesn't apply to a Roth IRA because with a Roth, you've already paid the tax before you invested it. You're taking after-tax dollars, and it's able to grow, but when you take the money out, you don't pay the tax, so you don't have the required minimum distribution. So the stretch is an estate planning strategy that existed and worked, again, before the Secure Act, where, keep in mind, the required minimum distributions are over your life expectancy. And the same rule would apply to whoever inherited your IRA. As long as you had you'd reached the age, 70 and a half at the time where you had to start taking out the required minimum distributions, if you left that to someone other than your spouse, they would have required minimum distributions, and it would be based on their own life expectancy. So, for example, if you would leave the IRA to a younger beneficiary, that person who has a longer life expectancy is going to have to take out the money slower than someone with a shorter life expectancy, because they're, again, dividing the account balance by the life expectancy. So this can stretch out the amount of time that there's a tax deferral, and the idea being that the longer that you can delay paying the tax, the longer the money can grow tax-free, and the higher return you can receive on that investment, because the longer you can avoid paying the tax, the more it can grow before you pay the tax. With the Secure Act, it essentially prohibits the stretch. The Secure Act makes it clear that you now have 10 years from when you inherit the IRA to take all of the money out of the inherited account. So if the person who had the IRA had reached the age of 72, they were taking out required minimum distributions, and you have named your beneficiary to receive that inheritance of the IRA, now it doesn't matter what their life expectancy is. They no longer take out required minimum distributions, but within 10 years they must take that money out of the account. So let's see what kind of an impact that would have. Let's say, for example, that someone who is 75 and they're taking their required minimum distributions on their traditional IRA, and they have named someone who is 45 as their beneficiary. Maybe it's a grandchild, or they have younger children, and so this is someone who has a life expectancy when they inherit that IRA of almost 39 years. So when they inherit that IRA, they're going to have 39 years to pay out that balance, and it's going to be tax deferred. Every year they'll take their life expectancy, which is still going to be long, and divide it into that balance, take out that amount. Because their life expectancy is longer, their required minimum distribution is smaller, and they have a longer period of time for the tax deferral. Under that scenario, if you're 45 and you have an almost 39-year life expectancy, that's 39 years that you have of tax deferral on that inherited IRA, on top of the amount of tax deferral the person who originally had the account received. Now, under the Secure Act, if you left that same account to a 45-year-old beneficiary, that person would have 10 years to take out the money from the account no matter what. So and they don't take out required minimum distributions any longer, but they must take out that money in 10 years. So under that scenario, they've lost 29 years of tax deferral, and because of the fact that the stretch has been eliminated. So you can see why this is such a significant change to the rules for inheritance, and why this could greatly impact your retirement plan and also your estate plan. The federal government estimates that with this change, with the elimination of the ability to use the stretch, that an additional $15.7 billion is going to be brought in revenue for the United States because of this change. There are some exceptions to the rules for the 10-year payout. The first is the surviving spouse. With an IRA, if you name your spouse as the beneficiary, then when they inherit the IRA, they're able to roll it over into their own account. So they don't have the 10-year payout because it becomes their own IRA. So it'll be subject to, if it's a traditional IRA, their own required minimum distributions based on their life expectancy, and then they can leave it to others, but unless they remarry, those others will have the 10 years to take out the money. Also, you can leave it, if you leave it to minor child but this is someone who has not yet turned 18, then the 10 years doesn't apply until they reach the age of majority. So for example, if in your state 18 is when you're considered legally an adult, once they turn 18, that minor child will have 10 years to take out all the money from that IRA. Then also, you're allowed to leave an IRA to a disabled individual without it being subject to the 10-year withdrawal requirement. And you see that throughout federal tax law and laws regarding transfers for public benefits, that you're allowed to, transfer money to individuals with disabilities. But when you do that, you have to be very careful, both in terms of, depending on the person's form of disability, can they manage the money, can they handle receiving an inheritance without some form of a trust and someone else managing the funds, and then also depending on their type of disability, if they receive this money, will this impact any government benefits they're receiving? Sometimes the inheritance could push that person off of government benefits that they depend upon, and they need some form of planning. Now we talk about exceptions. There are also alternatives that will be of greater significance now because of the changes to the stretch, the elimination of the stretch. For example, there are charitable remainder trusts where you designate beneficiaries to receive a portion of your inheritance and then leaving the rest of the trust assets to a charity. There are special tax rules for that, and gifts to the charity would be tax-free, so it's another opportunity to stretch out possibly the savings for the IRA. Also, we may see a resurgence of the use of whole life insurance policies if a person's goal is to transfer wealth to their children, their family, without any tax when they die. This is something that we saw more when the estate tax was lower and people were worried about trying to avoid that estate tax, where they may take money out of a retirement account and put it into an insurance product, because when it's passed on, the benefit isn't generally taxed. So these are things that you should be thinking about. They're things that you should be asking your financial planners, your advisors about, in terms of, hey, how does this significant change impact my own plan? And most importantly, with the changes to the stretch, it's time to update your estate plan. As I mentioned, if you haven't updated it in the last month, then there are changes to be made that need to take into account how the retirement accounts are going to be handled, because a lot of the planning strategies that made absolutely perfect sense before the Secure Act passed could cause, to expose your life savings to taxes to your loved ones because of the changes that have occurred in this act. So I encourage everyone to use this as an opportunity to either reach out to your estate planner and kind of look at your plan again, or make sure your clients know, or anyone that you're dealing with, that they are considering how has this changed their estate plan. I hope you found this information to be useful. Please keep in mind that this is a general description of the Secure Act and is not intended to be specific legal advice for your own specific situation. If you have questions about how the Secure Act may impact you, or if you think it's time to update your estate plan, I'd be happy to answer any questions you may have and help out however I can. So please feel free to contact me. Thank you.